Thank you.
Thanks.
Good morning, Mr. Marshall.
Good morning. May it please the Court. John Marshall for Bar Counsel. This is a bar discipline case that, in which the respondent lawyer knowingly made false statements under oath on a probate court financial statement and other papers in order to influence support orders in a pending matter. Bar Counsel has appealed to this Court from the Board of Bar Overseers' decision to sanction the respondent with a public reprimand. The Board has justified a reprimand in this case with a number of factors in mitigation, but primarily with fear and stress purportedly suffered by the respondent when she filled out her financial statement. This factor should not justify less than a suspension in this case and was, in any event, not supported by the record. First, let me spell out what the respondent's misconduct was in this case. The special hearing officer found that the respondent knowingly understated her income and assets on a financial statement that she signed on July 27, 2001. The special hearing officer also, however, specifically found that the respondent's misrepresentations were made to influence support orders in the matter pending before the probate court.
Was the state... Go ahead.
Was the finding that it was knowingly understated, or just that it was one of, because there was such a discrepancy between the two, the mortgage application and the support order, that clearly there was an intentional misrepresentation one or both places?
The judge specifically found that the representations in the financial statement were intentional misrepresentations,
But what
I
he
believe.
says is they reflect a purpose that takes her inconsistent statements a step beyond carelessness. I
Yes.
therefore find this misrepresentation was intentional.
And I interpret that phrase, this representation, to refer to the representations as to the financial status in the financial statement.
Is the financial statement made under oath or under the pains and penalties of perjury?
Yes, it's made under the pains and penalties of perjury. And much of the evidence, as we've just fleshed out, much of the evidence involved this discrepancy, this disparity between the financial statement and a mortgage application, and in comparing those documents, the special hearing officer noted what he called, and I quote, a persistent pattern of stating contradictory facts so that the facts in the particular instance in which she set them out would be advantageous to her. And later the special hearing officer noted, as was just noted, that the variance reflected a purpose that takes the matter beyond, makes the misrepresentations intentional.
And from your perspective, I'm sorry to interrupt you,
Okay.
but would the fact that I gather not terribly long thereafter, there was an amended financial statement filed after the respondent had counsel and conferred with an accountant, I believe.
Yes.
And so in terms of any impact, I gather it's not disputed, there was no impact by this misrepresented filing.
That's correct. That
doesn't matter to you.
That has limited value in terms of the sanction. It's also important to note that the amended financial statement was filed 2 months later, but not until after the financial statement had been presented in a hearing on a support order on August 23rd. And at that point, Mr. Tabo's lawyer presented evidence to the court that, in fact, the respondent owned a $30,000 bank account that was not listed on that financial statement. The judge noted that the respondent was a member of the bar and that the financial statement had been signed under the pains and penalties of perjury, and told her that she had to file a new financial statement
Well, actually, they both
disclosing
did,
her
right?
assets.
They both had to.
Yes, that is correct. There were apparently deficiencies in the Mr. Tabo's financial statement as well, which is not in the record.
Mr. Marshall, I'm
Yes.
correct, am I not, that this lawyer had been the victim of some quite terrifying acts of violence that put her own life and the life of her child at risk, correct?
Yes, that is correct, Your Honor.
I'm
Approximately.
also, am I correct that while she was filling out this, her alleged abuser was sitting for some reason next to her?
Yes.
And am
He
I-
was filling out a financial statement as well, Your
Do
Honor.
you think that we should accept the judge, not the judge, the hearing officer's view when addressing her claim that she was, that the fact that she was subjected to domestic fear and stress, and he dealt with that by saying the practice of law frequently subjects lawyers to stress? Are we really talking apples and apples, or are we talking apples and oranges?
I believe that it was appropriate for the special hearing officer to make a judgment as to the extent of the stress that the respondent was feeling on the day that she found that she signed the financial statement, based upon her testimony, and that's the important point.
Are you saying that he, from that paragraph, which I think is the only place where he addresses his view as opposed to what she said, is that he had taken into account, he thought that the degree of stress that she was undergoing is what you and I might, the stress that you might have felt when you were preparing for this argument, for example?
Exactly, Your Honor. The special hearing officer was making a credibility determination as to the amount of that
Was he taking into
stress.
account any of the particular circumstances that attend, well documented, that attend victims of domestic violence, particularly in court proceedings?
We don't know that, Your Honor, because there was nothing in the record to that effect.
So what is there to support the judges apparently making an equivalency argument that the fear that you experienced when you were sitting waiting for this argument is the same fear that she experienced sitting next to her abuser?
All I can say in response to that, Your Honor, is that the judge was limited to making his decision, his determination as to the extent and the effect of that stress on the record before him. And the only evidence in that record was the oral testimony of the respondent before the special hearing officer.
And what
He
did
had
she
an
say?
obligation to make a decision as to whether and to what extent he believed that testimony. And I believe the record is clear that he accepted that there was some stress in equating it with the type of stress felt by lawyers in practice. He's making a credibility determination as to the extent of that stress. And the board had no basis to go beyond that on the record. And in doing so, they invaded the province of the special hearing officer as the sole judge of credibility.
Refresh my recollection, when these financial statements, these particular financial statements were being filled out by her and the person she'd accused of abuse.
Yes.
Was that in connection with a hearing to extend the 209A order?
Yes. The case was on for an extension of the 209A, that order that day.
And they filled that out in advance of that hearing?
Yes, that is correct. According to the testimony, both parties were asked to see a family services officer because there were children involved, and the family services officer asked them to fill out financial
Well,
statements.
and she was seeking child support.
Yes,
That's
she
the reason,
was.
I
Yes.
assume.
Pardon?
I'm assuming that because there was an issue of child support, that is the reason for filling out the financial statement.
Yes, that is correct. And in fact, if you look at the record, specifically the application for a 209A order that the respondent had filed on July 13th, 2 weeks before, there is a standard form and there's a box to check off if you're seeking support if there are children involved. That box is checked off on the application that was filed. There's no testimony about who checked it off, when it was checked off, but an inference is there that it was checked off by the respondent when she filed the application. There's also evidence that that day on July 27th, the respondent specifically asked the court for a support order. On August 23rd, when the respondent was before the court on a support order, we have a transcript of that testimony, and the respondent stated that on July 27th she had made an oral motion for child support. The judge had apparently suggested she come back later. But the issue of support was before the court.
Let me ask you this. If she had provided the information that she provided for the mortgage application to the court when she was applying for custody, what would the effect have been on custody, on any custody order?
I don't see the effect of having any
Custody wasn't at issue, was it? I mean, other than the state.
support. Okay. I don't know what effect the disparity in income would have had. I can't believe that it would have had no effect. There was some testimony on the record from the respondent's lawyer who subsequently represented her, and that testimony is there. She discussed to some extent what impact the various financial statements have under the child support guidelines. And I believe her testimony was that it would have had little effect, but I'm not sure whether it would have had none effect. But that is testimony on the record.
Mr. Marshall, let me ask you this. You said that the only thing that the hearing officer had in front of him was her testimony. I don't know whether this was admitted in evidence, but certainly her lawyer quotes from it extensively about the testimony of the lawyer who subsequently represented her, asking about her state of mind.
Yes.
Is it your view that we disregard that?
No, I believe that testimony is consistent with the respondent's testimony and does no more than create a credibility question because it's from the lawyer. It's hearsay. The lawyer is testifying as to what the respondent told her, and I don't believe that there's any major consistency between what the lawyer testified and what the respondent.
Except that she testifies that she was in fear of her life. This was the first time she had seen the man who had put her, if the fact, in fear of her life, and almost could have killed her child. She hasn't seen him. This is the first time that she's seen him. She doesn't have records with her. I mean, I think that, again, I'm going back to the hearing officer saying, well, that's really no different than the tension that a lawyer feels.
That's the testimony from the lawyer was consistent with the respondent's testimony. The respondent essentially testified to the same effect, and the special hearing officer had an obligation to make a credibility determination as to that testimony.
Well, if his credibility determination is, I find it incredible or not credible that she was so fearful that she really was, that it was, she didn't really know what was going on, or she didn't have a grasp, that's one thing. But to say, I just equate this level of fear, I'm afraid, tends to suggest that this is somebody who is not giving any attention to the particular circumstances of domestic abuse. It may be that is warranted, but it strikes me as peculiar that the hearing officer would resurrect perhaps his own fear of when he was a lawyer and say this is the same kind of fear. I mean, that's what struck me as unusual. And so when you're saying to me what the board did was improper, I think if I were a member of the board, I might say, well, perhaps not. You can go back and look at the testimony.
I agree, but the problem with looking at the testimony, Your Honor, again, is that testimony was subject to credibility determinations.
But he's not making a credibility determination. He's making a comparative of fear determination, and I don't think there's anything in the record that tells him what the degree of fear is in the, quote, normal practice of law.
I disagree, Your Honor, with all due respect, because when the special hearing officer found that the misrepresentations were intentional, after reviewing the representations in a number of documents over a period of time, he was by necessity rejecting the credibility of the respondent's testimony that her misrepresentations were negligent because she was in fear and distracted and didn't have her records. That's the basis of our argument that the special hearing officer discredited that testimony, and the board in its memorandum acknowledged that in affirming the special hearing officer's finding of intentionality. They acknowledged that there was an appropriate an appropriate discrediting of that testimony by the special hearing officer on the question of intent.
Mr. Marshall, as you know, there's 2 other cases on involving a similar
Yes.
Violation. And in reading the other briefs and in reading some of the cases from other jurisdictions, there is a huge range of sanction that is imposed for intentional misrepresentation under oath to a tribunal.
Yes.
By a lawyer.
Yes.
The recommendations by Bar Counsel were different in each of these 3 cases, or at least in 2 of them, and that may have had something to do with a recognition of mitigation. My question to you is, what do you personally, and what does your, if your office does not have, if Office of Bar Counsel does not have a general sense of the presumptive range of sanction, apart from mitigation, for intentional misrepresentation to a tribunal?
The sanction for an intentional misrepresentation to a tribunal is 1 year under the Knightla case. That case has been widely regarded as setting a presumptive sanction. If the misrepresentation is under oath, a longer suspension is warranted, and those range from 2 years all the way to suggestions that a disbarment would be appropriate. In this case, we do have an intentional misrepresentation. We do have under oath. However, we also have the Finnerty case. And we relied upon the Finnerty case in trying this case and in making a recommendation of a 6-month suspension because we believe that this case was essentially on all fours with the Finnerty case, in that the Finnerty case also involved false statements by the respondent under oath in a financial statement in a probate court
Is
matter.
Finnerty an anomaly? Is it out of line with the other cases?
It is, but it was a decision that was affirmed by this court. It is perhaps explainable as a distinct area in which a respondent's written financial statement in a personal divorce is involved. It's not justified that way by the court in its decision, but it is controlling precedent, and that's what we relied upon in this case.
Thank you, Mr. Marshall.
Thank you very much.
Mr. Rosenthal?
Thank you. May it please the Court. I don't know if I'll get through a 1.5-minute introduction before I get questioned, but if I can, I'm going to try to say that if I ever write my memoirs, I'm going to entitle this chapter "The 8 Shocks of a BBO Case." And in this case, it's just been one shock after another to me, and I'm going to tell you the section headings and see if I can get through the headings before I get to the issue of whether there was any misrepresentation at all. The headings would be, first, that a scattershot vendetta by an abuser can be taken seriously. Number 2, that Finnerty, the 800-pound gorilla in the room, could be taken seriously as a comparison. Number 3, that the hearing officer compares the stress in this case to the stress of the practice of law. Number 4, that the mortgage form was taken seriously. Number 5, that a 2-month suspension was recommended on the basis that it wouldn't hurt her nascent law practice. I think I've lost count here, but the next one is that Haichi goes haywire, is what I'll call the next section. And the last 2 would be that Bar Counsel appeals this reprimand to this court and isn't satisfied with it. And finally, that nobody has yet taken seriously the argument about what I call my public policy argument, that this is a woman that comes to court for refuge for a 209A order.
Well, you may not be able to hit all of your points.
I understand that.
I'd like to, you acknowledged that she filled out a mortgage application on July 9th in which she claimed gross income of $14,598 a month. That works out to $3,650 a week. And that she said she had a car worth $3,500 and 3 bank accounts totaling $4,800. And then she's in court and she states that her income was $600 a week, not the $3,650, and that she had an automobile valued at $2,000, right?
Correct.
So the only question is whether she knowingly did this or negligently did it.
Actually,
agree with that?
with all due respect, I don't agree with that, because I think the first question is it a misrepresentation at all? And that has been blurred by both the hearing officer and the board, and they just use this terminology.
Reported in court was signed under the pains and penalties of
But
perjury.
I don't believe it's a misrepresentation at all, let alone intentional.
bar, come
I'm sorry?
But why? Why isn't it?
Because the numbers, if you look at the numbers comparing these two forms, and this mortgage form was never the focus of the case until the hearing officer report came out. If you look at Bar Counsel's argument at the hearing and their proposed findings and rulings, they focused on two things much more than the mortgage form. Number one was the issue of marriage, which the hearing officer said.
Okay,
she-
but
Well, I
what
didn't
about
get into
what
that.
about, and forget the mortgage form for a minute, just what about the, are you saying that it was accurate, that the representations in terms of weekly income, of having no bank accounts, all those things were accurate?
Well, the no bank accounts, the board did the right thing on that. It's a footnote in the board decision that she didn't put anything down there because she didn't know the numbers. So they said that's not a
She
misrepresentation.
didn't put anything. She didn't
I'm
put
sorry?
zero. She just didn't.
She didn't put any
it's
numbers.
blank.
She
It's
didn't put
blank.
zero. She left it blank.
And I take it that it was also, I take it from this that when she came to get an extension of a domestic violence restraining order, she didn't know that she was going to have to fill out a financial form.
That was her testimony, that somebody said, what about
not
child
a-
support? Go downstairs. And then they tell this guy to go downstairs too, and shockingly, he's sitting next to her. And
What
she-
is the significance, or is there significance to the fact that she underestimated all of her assets? I mean, I think it would be, it might be a very different situation if, okay, she didn't know she was going to have to fill this out, and she was under stress, or she made mistakes. Some were underrepresented, and some were overrepresented, and maybe some were even right. But isn't there significance to the fact that all the assets were underrepresented?
Actually, respectfully, that's not the case either, and this gets me back to Justice Ireland and Justice Bartlett's question, because the most critical issue as to any misrepresentation at all is the $600 figure. And in fact, that was too high. The one single piece of evidence that's the most conclusive as to her income is her tax return for that year, which is not filed till later.
But that's not the most. This is gross weekly income.
Well-
This is not net income. This is not take-home pay.
Different.
She puts both, which shows how careless she was at the time. She put $600 for both. She just wanted to get out of there, and that's in the testimony. All she wanted to do was get out of there. She put $600. It's Exhibit 10.
It's underestimated compared to what she stated in her mortgage application.
Correct, but there's testimony what that mortgage figure meant and how it happened, and it was before this subprime stuff, but it all started ringing true when I started hearing about the way mortgage officers were acting.
Why
that it
would-
was-
Why was the mortgage estimate used as the benchmark for accuracy?
I was shocked when that happened, when the hearing officer did it it became the new 800-pound gorilla in the room. I was just shocked, because if you look at Bar Counsel's proposed findings and conclusions before that hearing report, there's like one sentence about the income figure. It's all the assets, and it's all the marriage. There's 2 pages on assets and 2 pages on marriage. One sentence about the income figure.
Was there evidence to support at least the approximate veracity of the figures she had put in the financial statement that was submitted to the probate
The
court?
evidence as to that was it was a guesstimate. I was trying to get out of there. Here she is in her
So
first...
what are the true figures compared to?
The true figures, I think, are her tax return a year later, which is a $21,000 income.
But gross income of $316,000.
Correct, because that's a business that she's running, and the testimony as to the the gross income figure in the mortgage form says that she told the loan officer, this is a business, I pay payroll out of it, it was temporary employment.
But the tax, I thought the tax return had a gross income figure of $316,000.
That's also for the, I think that's for the business. I don't remember
Okay.
candidly, I'm sorry. But in any event, I think the most important figure for this court today is the taxable income figure in the tax return the next year, which is Exhibit 27, and it was, I think, $21,000.
If we use that as the most accurate source of information, didn't she explain that she was an unmarried head of household on that, on the tax returns?
A year later, yes.
And then she say in probate court that she and Mr. Tabo had been married?
Yes, and
So
that's an issue.
that wasn't true, was it?
Actually, it was true and it wasn't true. I'm sorry to dodge that. I'm not trying to dodge it. The hearing officer said that it was reasonable for her to think she was married because there was an elaborate marriage ceremony in Cameroon. In fact, it was not legally valid because she had a 1991 marriage that she never got divorced.
Till
And
later.
that was an error. And there's only one place on all these forms where she says she's the lawful wife, and it's a pre-printed court form that she signs it. It says lawful wife. I'm not justifying her saying that she was a wife. That was a mistake. But they called themselves husband and wives. He called her his wife. There was ample stuff in the record to say that. The hearing officer cut me off on the proof on that and said, I'm prepared to rule that it was reasonable for her to call herself a wife. I think you should move on. And that's all documented in my brief. And
How does it affect the income? Does she not claim an exemption or something like that?
I don't, that has, the wife issue, are you asking? Your
Yeah.
I don't,
Talking
the
about
wife issue has nothing to do with the income.
Just a question of what, if she filled out the tax form as a single head of household, and then, but in the probate court was
Yes,
still
I'm
allowed
not
as a
sure
wife.
the connection between the two questions.
I
But
take it in any case that the claim for child support is not dependent on marital status.
But
Absolutely not.
But health insurance is.
Yeah.
Yes, no, actually, she was entitled to the health insurance anyway without the marriage. Her health insurance, I suppose, would have been. I don't know domestic work, but there was testimony.
That was the purpose of this form.
There was testimony by her lawyer, Joyce Kaufman, as to the implications of all of this, and the hearing officer ignored it. The board basically ignored it as to the legal implications, as to her state of mind that summer, basically all ignored. So I'm asking this court to look at the picture of what was happening on July 27, 2001, not only as to whether there's any misrepresentation at all, which I do not concede. This has never really been looked at, partly because of what the board did in misapplying H.E., which was an astounding line of reasoning. This was by necessity declining to credit her testimony. I mean, that means that any time someone testifies and gets ruled against them, it could be called by necessity declining to credit their testimony. And I've briefed this issue at length, and I'm not going to get into the legal issue. But the point is, there's been no examination of whether there's an actual misrepresentation, and I believe there wasn't. Now, as to whether it was intentional, and actually the rules say knowingly, but I don't think it makes any difference. This has been called intentional. The only basis for that finding, along with the H.E. reasoning, which I think is clearly wrong, was that it was, excuse me one second, the market variance between the figures with the mortgage form and the stark contrast. And if there's no real significant variance and no important misrepresentation, then how big a market variance and how stark a contrast is it? The comparison to Finnerty is another thing that's been flabbergasting. It's been in this case since...
Could I ask you to go back to something, please? I seem to have a note that she stated on her tax returns for 2000 and 2001 that she was unmarried. Yet here she stated that, what did she state on the, in the matter and issue, where she was filing the claim for support?
She said wife. In one document that she prepared, she said wife. Actually, I can't remember if she said she was the wife or he was the husband. And on one form she signed, there was one of the many pre-printed lines said lawful lawful marriage or lawful wife. So
She also submitted an affidavit, too, didn't she?
Yes, that's what I'm saying. Something that she prepared, and that's where she said wife. She didn't say lawful wife in that one. But I'm not disputing that was wrong. I think it was a mistake. I think it was negligent. I don't even think it's sanctionable, to be honest, because of the finding of the hearing officer that this was reasonable. They called themselves husband and wife. They lived together for, I think it's 6 years, but I'd have to check, as husband and wife. There's letters from him, dear wife. He got health insurance for her as his wife.
The question is not whether it's reasonable in that sense. The question is misrepresenting herself differently depending on whether it was to her advantage or not is the issue, not that she... I mean, on her mortgage application, she represented herself one way, other places other ways, tax returns a third way, depending on whether it would work to advantage, which goes to the issue of whether this was knowing and intentional conduct versus simply negligence.
That's a legitimate inference question, and what I'm suggesting is that that inference is not a reasonable inference from the record, given the circumstances of the way this was done, and her testimony as to what happened that summer and how she filled out these documents. The fact of the matter is that the issue of the child support, she was going to get it either way. There was no dispute about paternity. So I'm not condoning the mistake. I think it was a mistake. Was it negligent? The hearing officer said it was reasonable. I might even concede it was a negligent mistake. But under the circumstances of that summer, I don't even think it was sanctionable, the wife issue. But the point I was making at the beginning was this and the assets, the bank accounts especially, were the focus of Bar Counsel's litigation.
Well, the bank account is somewhat significant given her overall income. Am I right? The bank account showed $31,000?
Well, I don't remember the exact date that they showed that, but her attorney, Joyce Kaufman, said that those amounts would not have mattered anyway. But the fact is she did not misrepresent those numbers. She didn't have anything with her. When she did the mortgage form, she gave all her documents to the loan officer. They prepared that mortgage form. So,
but then did she sign it?
The mortgage form she signed, yes.
Oh, again? Okay.
But she didn't have any of that with her the day she was there. She didn't know she was going to do this, and that's in the record, that she didn't know she'd be doing this. She did it with this guy. I have to be careful how I talk about him, but sitting within 5 feet of her. And she just didn't know, so she put nothing. All she wanted to do was get out of it.
How much time passed between when she did the mortgage application and she filled out the...
It's a matter of weeks. I'd have to check the dates.
Like 2 weeks?
That sounds right. That sounds right, yes.
July 9th to 27th?
It sounds right. I'd have to double check that, but I know it was the same month. And I don't think it was the first week of July, so it was a short time.
So what do you say about Finnerty?
I can't believe this is compared to Finnerty. I mean, Finnerty is a case where hundreds of thousands of dollars were secreted in his assets.
Well, then why shouldn't it be compared to Neatlick?
I think if you look at all the cases, including Neatlick, including Finnerty, I cited a whole bunch of them in my brief on page 45. I think it comes much closer to all the minor cases like Bernardo, Ferry, Palmer was a public reprimand, Cross, Kelly. I mean, each of these cases is different, and you can compare each of them and try to decide which comes closest, but each one is sui generis. I don't think the misconduct here, if there is any, rises to the level of Neatlick. I don't think it even rises to the level of all those other cases I cited, all of which were public reprimands. I think all of which, but anyway, many of them were. So when you look at these cases, and I see I'm running out of time, I just don't think the mitigation was factored in enough, the public policy issue, and I know I'm not likely to get it, but as to my request for costs, I think John Marshall is as good a lawyer as in the state. He's very honorable. It's not directed at him. I just think there's some checks and balances that are needed here, and it's directed only to the question of whether they should have appealed the reprimand to this court. That's the issue that I think was off, and they should not have done it. So thank you.
Thank you, Mr. Rosenthal.